Next case to come before the court is State of Ohio versus Timothy Dale and Monte Clark. Each side will have 15 minutes to present its arguments. The appellant again may reserve up to 5 minutes. Just let me know when you take the podium if you wish to reserve time and how much. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. You've read your briefs and you get ready when you are.
Eric Hall on behalf of the appellant Thomas Dale Monte Clark. I'd like to reserve 5 minutes of my time for rebuttal. Thank you. Appellant Mr. Clark was charged and convicted of domestic violence, 4th-degree felony, received a sentence of 30 months in prison. I have 2 assignments of area on sufficiency of the evidence and manifest weight of evidence. Particularly, I'd like to focus the court on the issue that the state failed to establish an essential element of this offense, that is that the appellant and the alleged victim did not cohabitation. I think there's ample evidence to show that in this case, cohabitation requires 2 elements: sharing familial or financial responsibility and or consortium. Okay. In this case, we're not arguing that it was not the element of consortium. It was. It's the first element, sharing familial or financial responsibility. The record is replete that the appellant and the victim in this case, referred to as Ms. J, were not family members. During the course of the investigation, Ms. Jones told the police that the appellant did not live with her.
He wasn't allowed on premises at that time, either, was he?
No, he was not, Your Honor. That's I also think that's evidence that shows why there was no living arrangement. They were not living together. He was not on the lease. Okay, so this was an apartment that they're sharing together. He's not on the lease. He could have been or would have been on the lease, but he's not. There was he was banned from the property by the apartment complex. There was a no trespass warning letter that the police were trying to serve on him. At that location, they couldn't find him. The reason they couldn't find him is because Jones doesn't live there. That's why they couldn't find him. He went there before. Okay, I'm not arguing that he never went there. They had some type of relationship. There's no bank account together, Your Honors. The appellant provided no financial support whatsoever. There's nothing in the record that shows that he was supporting the victim in any way, sharing any expenses with her, doing anything that a normal couple that would be family members would do ordinarily. In this case, even boyfriend and girlfriend just wasn't doing it. This relationship, I would argue, was not a serious and committed relationship. It seemed to be quite casual.
The state seems to be arguing that there was testimony regarding him doing chores, taking the trash out, doing certain things relative to what needed to be done at Ms. Jones' house.
I think there was also some conflicting evidence that somebody saw him there and then they never saw him again. So it seems to be that what I would tell the court is that there's no testimony that said somebody saw him there on a day-to-day basis, like they were living together. And then her own statement to the police that we're not living together, I think that carries quite a bit of weight as far as evidentiary value in this case, Your Honor. She's the alleged victim, and if they're living together, who would better know than the victim in this case?
I don't know that this was in the record or not in the record. Was this Section 8 housing?
Your Honor, I'm not sure. I'm sorry.
Okay. It would make a difference as to whether she admitted he was living with her or not, because my recollection is he had just gotten released from prison.
You're right about that. They have rules and regulations, and you violate them, you can lose your Section 8, your voucher, your ability to do that through Minnesota. I don't believe that it came out. I don't remember seeing that in the transcript. I don't want to say on the record though that it is or is not there. I'm not sure, Your Honor. So I think in this case, Your Honor, there certainly was doubt as to whether they were living together. That's an essential element of the case. Without that element, then what you have, at best, maybe is a simple assault in this case, okay? Which, that's not going to result in a 30-month sentence in prison, and that's what he got, because this is a 4, so the court sentenced him, and the sentence was certainly within the discretion, it was a lawful sentence within the discretion of the court, based upon the conviction. But what I'm arguing is that the conviction, there was insufficient evidence to show that that essential element of the offense occurred, and also the conviction was against manifest way of the evidence. I think the jurors lost their way because there was some testimony that they had some type of relationship together, so the jurors believed in error that because they have some type of relationship, that means that this is domestic violence because their boyfriend, girlfriend have a relation. That is not an element of domestic violence. There's more. That does not meet the statute. And I think the jurors lost their way in this case. We'd ask the court to reverse the conviction. Thank you.
All right, thank you.
Morning, Your Honors, and may it please the Court. I'm Vince Bellucci with the Medina County Prosecutor's Office for the State of Ohio. The family or household members argument. Miss Jones was a family or household member to Clark because she was a person living as a spouse, as that term is defined in the revised code. And the most common way to meet that definition, obviously, is by cohabiting with the offender. And that was the case here. The Williams case, Supreme Court of Ohio talks about the two prongs of cohabitation as one, sharing familial or financial responsibilities, and that's an important or, not an and also consortium. Clark only is disputing that first prong. He doesn't dispute that he and Miss Jones did have a sexual relationship, a romantic relationship, and that the consortium prong is satisfied. And they were living together. And that's what Ms. Jones testified. She testified that Clark got out of jail in December of 2017 and immediately started living with her in Medina. And it's not clear in the record if this is Section 8 housing or what kind of housing this is, but they were living together in an apartment in Medina. And Ms. Jones testifies that they began a romantic relationship at that time. The two of them, she testified, shared a bedroom, and Clark had clothes and a toothbrush at her apartment. Ms. Jones testified that the two were sexually involved, and that Clark also, as was mentioned, did some household chores like cooking, cleaning, taking out the trash. And even if, as I said, Clark wasn't helping out Ms. Jones financially, he wasn't on the lease, that those things don't matter. The Williams test is sharing financial or familial responsibilities. And I do point out the Carswell case, just talking about it's a person's determination to share some measure of life's responsibilities with another that creates cohabitation. And that encompasses a lot more than just finances. He may have been banned from the property, but he was living there. He wasn't on the lease, he wasn't paying anything, but apparently, but none of that is needed for cohabitation. And I think I sort of buried the lead here because the McLaughlin case is critical. The Supreme Court of Ohio case says that where the victim and defendant share the same residence, that's enough by itself to establish cohabitation. You don't have to have evidence of shared financial or familial responsibilities. You don't have to have consortium to prove cohabitation in that situation. That's what we have here. These two were living together. Clark was her live-in boyfriend. They were in a romantic relationship. They shared the same bedroom. I also point out in my brief the Slevin case from this court, which is 2012, Ohio 2043. In that case, the victim lived with the defendant, had sexual relations with the defendant, but the testimony was that the defendant's mother actually paid for everything for them, and the victim did all of the household chores. So you actually had less than you had here. You have testimony that the victim's doing nothing, paying nothing, doing no chores, or that the defendant is doing nothing, no chores, paying for nothing. And even before the McLaughlin case, this court held that in that case, the victim was a family or household member, was cohabiting with the defendant. So I would submit that in this case, there's far more that establishes their cohabitation than there was in that case. In terms of the manifest weight evidence, the new argument there was that the state didn't prove by the greater weight of the evidence that Mr. Clark did this, that he caused or attempted to cause Ms. Jones physical harm. He essentially questions Ms. Jones's credibility based on the fact that the assault occurs on February 21st into the 22nd, but she doesn't report it to the police until the 27th, so 5 days later. But I think the jury probably understood that it's not uncommon for a domestic violence victim to not come forward until a little bit later. In this case, there was certainly there was an impetus on the 27th to come forward, and that was the threat of further violence. It looked like there was going to be a repeat incident of the 21st incident on the 27th, and that's what, there's a lot of testimony in the case about what happened on the 27th. Ms. Jones testified that she was scared of Clark, trying to stay away from him because she was receiving several threatening text messages from him on that day, and those were all exhibits at trial that you could look at. In one message, Clark texts, "I'm about to show you what I do to people I hate." A very hostile text conversation sort of ensues after that, where Clark even explicitly states, he says, quote, "I'm beating your ass when you get back." I don't know how much clearer it gets than that. He also accosted Ms. Jones in public that day as she was sitting in her car in traffic. He actually approached her vehicle on a bike. He opened Ms. Jones's driver's door. He grabs her keys out of the car. He grabs her phone out of the center console. He reaches all the way over in the center console and grabs her phone. He basically orders her to go home. And she says he has a look in his eye that makes her believe that there is going to be a repeat incident of the 21st. Instead, she thankfully does not do that and goes to her mother's house and has her mother call the police. And that's how the police do finally get involved. The jury certainly doesn't seem to have found her testimony any less credible just because she contacted police 5 days after the first incident. Or the fact that she didn't discuss the first incident in her first written statement. She actually she was focusing on what happened on the 27th in her initial written statement. And then she goes back to the police station the very next day after that, on the 28th, and she does provide a second written statement that addresses what had happened on the 21st. Certainly her testimony was enough in terms of sufficiency and manifest weight, but the state actually presented 7 uncontroverted witnesses. Several police testified about the pursuit of Clark as he fled the scene, which is certainly indicative, I would submit, of consciousness of guilt. It was not easy to apprehend him. They had to chase him halfway across Medina to apprehend him. Ms. Jones' testimony about the incident itself could not have been more clear. It never changed. She testified that Clark, he wanted to take her car, and she was saying no, and he squirts a drink on her, and then it escalates quickly to him punching her repeatedly with closed fists, pulling her hair, kicking her in the face, hitting her in the back with a broomstick. She testified that this beating lasted most of the night, with some breaks in between, but there were also photographs that the state introduced at trial of her face that were taken, that were taken by her sister the next day. She did go to the hospital. The pictures showed bruises around Miss Jones's nose, her eye, her face. It showed a knot above her left eyebrow. So certainly there is more than just the victim's testimony here, although that is enough. I would submit that the evidence weighed heavily in favor of Clark's conviction. Is there anything further?
Thank you.
Thank you. I just asked to affirm the judgment of the trial court. Thank you.
These things that the state's talking about, closing a toothbrush, sharing a bedroom on occasion, sexual relations, that suggests consortium. That's what it suggests to me. It does suggest that they're sharing that they're familiar responsibilities and financial responsibilities. That's the issue in the case. Threats, the alleged acts of violence. Still, all these things taken together, even if true, still don't meet the statute as far as domestic violence if you don't meet the element of whether or not there's either a family relationship or a household member, which is what we're arguing here today, that they weren't living together and that relationship did not exist. The only part of it was this consortium. They were, he did not, she's told the police officer he did not live there. He was not allowed to be there. The police couldn't find him. I mean, before he knew that he wasn't allowed to be there, they were trying to serve a no trespass warning letter, and they couldn't find him anywhere. They couldn't find him because he doesn't live there. If he lived there, he would be easy to find. If you go there, he's not there. Come back an hour later, 2 hours later, the next day he's there. There he is. That didn't happen. He doesn't live there. This was an on-off relationship. As far as the threats, the texting, that's not does not necessarily meet the essential elements of a domestic violence charge. Those are other charges. Menacing, assault, but not domestic violence if you don't meet the essential element of the statute, which requires them to be cohabiting, which the state failed to do that in this case. Your Honor, yes, it should be reversed.
Thank both of you for your presentations. The court will take the matter under advisement and issue its written decision, which will be mailed to both sides and posted on our website as well as that of the Supreme Court. Thank you very much, gentlemen.